The Honorable Justices of the Supreme Court of Appeals, Chief Justice Tim Armstead preside. Oh yeah, oh yeah, oh yeah. Silence is now commanded and the confinement of prison. While the Honorable Justices of the Supreme Court of Appeals are now sitting. But all persons having motions to make the appeals of prosecute come forward, we shall be heard. God save the state of West Virginia and this honorable court.
All right, this morning we have 11 individuals who will be admitted to the practice of law in West Virginia. Carol P. Smith, the Bar Admissions Administrator, will be presenting the motion on behalf of the 11 applicants.
May it please the Court, Carol Smith. I am the West Virginia Bar Admissions Administrator. I appear before the Court this morning to move the admission of 11 individuals to the practice of law in West Virginia. The following applicants have successfully passed the West Virginia Bar Examination and seek admission to practice law under Rule 3.1. Jonathan Andrew Deasy, Barry Christopher Markham, Jacob Bradley Meller, Kathleen Elizabeth Robeson, Charles Michael Waddle. Pursuant to Rule 3.5, Andrew Todd Beatty seeks admission to the practice of law in West Virginia by transferring his uniform bar examination score. Pursuant to Rule 9.0, Nicholas Stanley Yokovich seeks limited permission to practice law in West Virginia in association with the Office of the Public Defender for the First Judicial Circuit, having been admitted in Pennsylvania and Utah. Finally, pursuant to Rule 4.0, the following individuals seek admission by reciprocity. Peggy Susan Ferraro, having been admitted in Ohio and Pennsylvania. Todd Andrew Fichtenberg, having been admitted in Michigan and Ohio. Robert Gene Miller Jr., having been admitted in Kentucky. And John Franklin Newsom, having been admitted in Pennsylvania. I represent to the Court that each of these individuals have satisfied the requirements to practice law in West Virginia and move the admission of these individuals at this time.
Well, thank you very much. Your motion will be granted, and I want to congratulate each of you. We're glad to have a group back in the courtroom being admitted in person, and we're very happy for you and congratulate you on this accomplishment.
All right, if you would all raise your right hand. And I will let you know that although Justice Workman is not here in the courtroom with us, she is participating remotely, and she is listening and viewing, and she will, I'm sure, join in the granting of these motions.
Yes, anyone that wants to take a picture, you can certainly come up.
Come on up.
Yeah, you can stand in front of us. It doesn't matter. Come on up. Come on.
Get over in the middle where you can see. You don't worry
No,
about.
you're fine. We can see. We do this all the time.
Do not worry about blocking us. Come on up here where you can sit. Go ahead, man. I'm sorry.
I do solemnly swear or affirm that I will support the Constitution of the United States and the Constitution of the State of West Virginia. I will honestly demean myself in the practice of law and to the best of my ability execute my office of attorney at law, so help me God. You may say, I do. Congratulations to all of you. You may be seated for a moment.
Again, we just want to congratulate you, and normally, in normal circumstances, we would come down and greet you and shake your hand and give you personal congratulations. Obviously, because of the circumstances we're in, we will not be doing that, but I did want to give each of the justices an opportunity to express their congratulations. And as I said, we're very pleased that you, in very difficult times, have been able to obtain this accomplishment, and we're very happy to have you as members of the West Virginia State Bar. Hopefully we'll see you again here practicing in front of us. And again, we certainly congratulate you and your family for all the hard work that got you here today. So with that, I will ask if Justice Walker would like to
Sure. I do love Admissions Day. It is probably my favorite time to be on the bench, even though we hear some important cases, and that's challenging and great too, but there is nothing like bringing new folks into the profession. Even those of you who are being admitted on reciprocity, and may seem like old hat, we do love our admission ceremony in West Virginia. I think it's different than any other state where we bring you into the Supreme Court, we're all here, and we welcome you. So I want to congratulate you and welcome you to the West Virginia Bar on behalf of myself, but also on behalf of Justice Workman, who is watching, I'm sure. Hello, Justice Workman. She would be here if she could, but I know that she would congratulate you as well. So I'll speak for both of us, and once again, welcome you to the practice of law in West Virginia. We look forward to seeing you back here soon.
Well, good morning, and let me also echo the sentiments and the congratulatory remarks from Chief Justice Armstead and Justice Walker, and soon also Justice Hutchison. Take in for a moment, I know getting here today, getting up to the chamber, thinking about what's happening, take that 10, 15-second pause and look around this room. Think about the accomplishments and hard work, your dedication to the profession, and your passion to help others. And we are living in unique times, but you are in a unique position to be able to have a huge impact on the people you represent. And this chamber itself has certainly a storied history, and it is a beautiful chamber. And I remember when I was sworn in here many years ago, and it was very impactful. So thank you for being here. Thank you for who you are, and thank you for your dedication to this profession and what it stands for and what it does in service to other individuals. So congratulations. It's a great day. A personal statement. Where's Carol? There she is. Thank you for your efforts because just in difficult times to make things happen, it takes extraordinary leadership, and you have certainly shown that in spades. So thank you for what you're doing. So congratulations, and take it all in today. It's your day.
What they said.
He always does that.
No, I'm the oldest member here today. I won't say anything about Justice Workman, but I'm the oldest member here today, and yet I'm the newest member on the court, so I always get to speak last, and everybody very eloquently cover me up, so I don't get to say a whole lot. It is great to be back in this courtroom and doing things. I was a little sad back in May. We actually had an admission ceremony on May the 20th, and we did that virtually, and I was sitting in my home office and doing it by computer. And that was the 40th anniversary of the day that I sat where you are and took the oath and was admitted to the bar. It is memorable, and having a ceremony in the courtroom makes it more memorable for you, because you hopefully remember where you were on this date and remember your surroundings. It is a significant accomplishment for each of you. Even those of you that have come in by reciprocity, it is an accomplishment to add another notch on your belt in terms of having an admission in a different state. So I congratulate all of you. The folks that have come with you, I know that you didn't get here by yourself. You had support behind you, and I congratulate all the folks that have stood behind you and helped you get to where you are. So my congratulations to all. Welcome to West Virginia and the practice of law in West Virginia, and I'll look forward to seeing you hopefully up here advocating for your clients.
And I'll just add our thanks as well as to Carol for all the work that she's done, but also to our clerk, Edie Geiser, who was a large part not only of putting this ceremony together, but of ensuring that the bar exam could go forward this year. So we want to express our appreciation to her for her hard work, also in very challenging times, and with almost a new challenge every day as we went through that process. So we want to thank her, and again, congratulations to each of you.
Congratulations.
All right, with that, I believe we're concluded. You've probably seen Alex Wilson here. He's our professional photographer. And so his photos from today will be uploaded. I'm not going to pass these out to everyone, but maybe as we leave, you can grab one. There is one for everyone, but you can grab one on your way out. And thank you for coming in today. I look forward to seeing you here again.
How many states canceled their bar exams?
They know how to delay them. There's a bunch going at the end of September.
Okay.
At the beginning of the bar exam for like an hour.
She is viewing and listening via the webcast, and so she will be participating in the decision and opinion in this case. I'll remind you that each side has 20 minutes to present your oral argument, and we have added a little clock to the left of the podium that you will be arguing from for you to help monitor your own time in the oral arguments. And with that, counsel for the petitioner may begin.
Before I begin, can I ask a question?
Absolutely.
This is actually my first time being here in 16 years of practicing law. It's remarkable. And then I'm here next week. But my question then is, I have 20 minutes. I understand that. Am I permitted to save some of it to go at the end?
So under our rules, the petitioner is invited to open and close the argument. You do need to use your 20 minutes to open and close.
Okay.
And so whatever time you believe that you might need for rebuttal, just maybe stop within yourself those few several minutes towards the end.
Okay, thank you.
Thank you.
Thank you very much.
Once you use your microphone or cover, then you may remove your mask.
Right.
While you're doing that, I'll just say we have the plexiglass pairs, and we're socially distanced, so we removed our masks so that we can ask questions. You may either leave your mask on or remove it while you address the court. That's certainly up to you, whichever way you're more comfortable.
Thank you, Justice. So my name is Alex McLaughlin. I'm here today on behalf of Marissa Schaefer and Timothy Schaefer. And this is a case about fundamentally it's about a wet tap and a number of complications, primarily mental, psychological complications that ensued after the wet tap, because the expectation for Marissa Schaefer was that this would be a joyous experience, a wonderful time, and instead it ended up being a very miserable time for her because of the wet tap and the 8 days of excruciating pain.
Well, wait a minute. fundamentally, you didn't appeal the finding that a wet tap is not medical negligence. Am I correct on that?
Oh, certainly I didn't. There is nothing that inherent in a wet tap. It is a risk of the procedure. It is not inherently it doesn't speak for itself as negligence.
So, but the real issue here is that you contend your client was not appropriately informed regarding the participation of a student in that procedure.
Correct.
And so isn't the fundamental question of whether or not the failure to inform constitutes and/or the resulting wet tap was the failure to inform was the proximate cause of her injuries that you claim?
That's correct. The judge did not, and I don't think that they even asked for summary judgment on the issue as to whether there was a question of fact on breach of the standard of care. Their motion was, even if we breached the standard of care, it wasn't causally related to the wet tap. The response was, yes, it was. The judge ruled, you haven't provided sufficient evidence for that. And so the rule in West Virginia in informed consent cases and cases involving a lack of informed consent, causation is the question of causation, and it's committed to the jury in almost every instance, is whether or not the person who says, had I didn't get in proper consent, had they gotten the informed consent, they would have chosen not to go ahead with the procedure, or in this case, insisted on some modification to the aspect, not consented in this case specifically to the participation of a trainee. And then that's a jury question, whether she would have reasonably done that. And I don't understand the judge's order to be disputing that. What the judge's order is saying is that, or what the issue on appeal is that the judge found that the trainee's participation that she might have declined was not causally related to the outcome, to the wet tap. And that's what I'm appealing. In reaching that ruling, the circuit judge relied exclusively on a single question and answer in the deposition transcript of Marissa Schaefer's expert, an anesthesiologist, and he relied on that single question and answer to the exclusion of all of the other testimony from that expert.
Counsel, it seems to me that you're attacking the more specific informed consent form from Dr. Bragg. Had the second, more specific informed consent never been executed, and the only informed consent form was the original, more general from CAMC, which obviously specifically under 7 references the participation of students, would we be here today if that was the only informed consent form?
Yes, the standard of care requires specific consent for a procedure, for a surgical procedure
So you're saying the more general informed consent has no bearing, or it was trumped by the more specific? What's the interplay between the two?
So the general consent form, there's lots of things that when you go into a hospital that they do. Nurses take your temperature, give you aspirin, take a history, repeatedly come and go, and people will come in and take a history, and that might include a resident. So general consent covers those things, and this was the testimony of both experts. Specific consent is required, is the standard of care for procedures, and procedures are defined as surgery or invasive anesthesiology procedures. That's primarily the 2 main categories of procedures that would be at issue that require specific consent. And it was not contested by the defendant's expert anesthesiologist that specific consent is required for a labor epidural. So now, if they had a form in obtaining specific consent that was different than the form that they used to obtain specific consent, that that spelled out some of the things that are spelled out in the general consent form, then we might not be here. And I say might not because I don't know what it would have said, I don't know what the facts would have been, but there is a circumstance there. But if we just didn't have a specific consent form, we would still be here because you need to have specific consent for a procedure. That's the standard of care. And the standard of care requires you to disclose in any procedure that a trainee is going to participate, who is on the team, who is on your care team for that procedure, and whether a trainee will be participating.
Had provision number 7, understand that this is a teaching hospital and the students in the healthcare sciences may observe and participate. Had that been included in the more specific verbatim, would that have rendered your case moot on this issue?
Well, if the specific consent form had said that instead of the patient authorizes Dr. Bragg or one of the physicians at GAS to perform the procedure, then probably, I mean, that's the answer. I would have to see what the language would be, and nobody, it's kind of a hypothetical that wasn't put to any particular expert in this case, but probably, I think, is a fair answer to that question.
Okay.
So that's why we're here today is specifically. I think that the fundamental issue before the court on the main motion for summary judgment is, does a single answer to a single question trump the testimony or relieve a circuit court of the obligation to review the totality of the evidence before the circuit court. That's what I consider to be the nub of this case, is what is required on summary judgment. So in this particular instance, I contend it was an ambiguous question and an ambiguous answer. Nothing about the informed consent process caused her wet tap, and that was a question that came. It wasn't apropos of the questions before it or the questions after it. I didn't object. He said no, and I think obviously if you read the transcript, and I said it in the brief a whole bunch of times, but if you're talking about informed consent and whether it causes a wet tap, to most people, that doesn't mean legal cause and but-for cause and all the very specific notions that are behind causation in the informed consent process, which is different than in just about any other process, in any other kind of legal action. It means, well, did something about it, this is to a lay person, including an anesthesiologist, did something about it cause the physician's hands to be unsteady? We'd say very, very specifically, did something about the trainee's participation cause the wet tap? And to that, Dr. Bushman said yes, and definitely, that because the trainee this is a kind of complicated issue, but the trainee started the guide needle and got it lost in the ligaments of her back and didn't know where he was. Most likely, according to our expert, he had actually entered, without realizing it, the epidural space where it should have been. But when Dr. Bragg, it's all done by feel. There's no sight in the common labor epidural. There's no X-ray involved or X-ray technology. So it's done by feel. So when Dr. Bragg took it over, he's assuming I'll take it over, begin to move it forward, and feel the ligaments as I pass through them, and then I'll be able to know. But since it was already in the epidural space, the first thing he felt was the wet tap. That's the position, that's been the position of our expert from the beginning in his addendum report, in his report, which was his certificate of merit, and his addendum report, which was he styled as an addendum to a certificate of merit in particular. That's where he said it, and then he said it in his deposition, and I quoted it a number of times in my brief. And that is a different issue. That's the nub of the issue. Had she said, I don't want the trainee to participate in my epidural, they would have been under a duty not to have the trainee participate. Then would the wet tap have occurred even in that circumstance? And I think, again, the evidence is, well, it's not undisputed, because their expert says, well, it could happen. It happens 1 in 150 times with a more experienced anesthesiologist like Dr. Bragg. It happens at a much higher rate with a trainee. Our expert said it definitely is. It definitely caused it. That Dr. Bragg, there's almost no chance. He has a very low rate of labor epidurals.
How do you get past that one question? And make sure I'm quoting the right question. Do you agree that nothing about the informed consent process caused the wet tap? Answer, correct. Is that the question and answer that you're talking about?
Yes.
How do you get past that?
Well,
That there's no proximate cause from, there's nothing about the informed consent process that caused this wet tap, which ultimately caused the injuries that you contend.
well, the question wasn't, there's nothing, there wasn't an explanation of what proximate cause is in the state of West Virginia to the expert. It wasn't clear that that's what he meant. And if you go by what proximate cause is in informed consent cases, meaning I get the right to say I want this or I don't want it, and he said very clearly, our expert said very clearly, she was denied that opportunity, that right, by the consent process that they played out, particularly by the specific consent form that she was signed, she was asked to sign. She was denied the right to say, I don't want the trainee to participate. And then the doctor said very specifically and very clearly, our expert said, if he had not participated, if she had that right and exercised that right, and he had not participated, the wet tap would not have occurred. So that's how we get through it. If you break it down by what proximate cause actually means in the context of an informed consent case in West Virginia, it's clear from all of the totality of the evidence that Dr. Bushman is saying there's proximate cause here under the legal standard. He doesn't know what the legal standard is. He doesn't know what the word proximate cause means. Or that it's got a very technical, it's a term of art in the state of West Virginia. He, as I said before, he's answering that question thinking, do you mean that the failure of the informed consent process made his hands unsteady? No. Do you mean that the failure of the informed consent process made her ligaments more difficult to get through? No. That certainly, at the very least, that's ambiguous, and the totality of the evidence suggests that there's a genuine dispute as to whether that's what he meant. The totality of his testimony is very clear that he is saying she was denied of the opportunity to say, no, I don't want the trainee to participate, and that had the trainee not participated, the wet tap would not have occurred. Their own expert said very clearly that he believed that when he was asked that question, he said it's possible that the trainee's participation to that point caused the wet tap or contributed to, made it more likely, but I didn't feel as strongly as your expert did about that. So their expert acknowledged that Marissa Schaefer's expert, Dr. Bushman, clearly thought there was proximate cause in the sense that proximate cause is defined in an informed consent case in West Virginia. I don't know if you have more questions. I'm happy to answer them. I'm otherwise going to save my time at this point.
No questions.
I don't believe there are any other questions, so thank you.
Thank you.
Now hear from the respondents, and just a reminder that both of you together have 20 minutes, so you hopefully have sort of divided that out among yourselves.
Chief Justice Armstead, may it please the court. My name is Amy Malone with the law firm of Flaherty, Sensabaugh, and Bonasso, and I appear today on behalf of the respondents, General Anesthesia Services, and Dr. William Bragg. This appeal stems from the Circuit Court of Kanawha County's granting of summary judgment to my client on two issues. First, the medical negligence claim, and second, the informed consent claim. And Justice Hutchinson, you're right, the medical negligence claim is not being appealed as part of this appeal. I think everyone agrees that the plaintiff's expert did not testify that my client deviated from the standard of care. Dr. Bushman, the plaintiff's expert, was clear that a wet tap, which is the injury at issue here, is a known complication of an epidural, of a properly performed epidural. It happens. And Dr. Bushman was not critical of my client causing the epidural. He believes it was my client that caused the epidural. My client has admitted, Dr. Bragg admitted during his deposition, that he caused the wet tap. But Dr. Bushman was very clear that that is not negligence. So the only issue on appeal is the informed consent claim. And during the deposition of Dr. Bushman, I took him step by step through each claim, the informed consent and the medical negligence. And we talked a lot in his deposition about what he felt was improper about informed consent. And he felt that my client needed to tell Mrs. Schaefer that the student was going to participate in the epidural process. Mrs. Schaefer testified that she knew a student was in the room. She knew from Dr. Bragg that the student was going to quote-unquote observe the procedure. So Dr. Bushman felt that she needed to know that he was actually going to participate. But you're right, the general consent form at CAMC says that students may participate in the care rendered in that facility. So after we talk about all of Dr. Bushman's issues with the informed consent process, I asked him if he agreed that nothing about that process caused the wet tap, and he did, correct. And that appears at Joint Appendix 147 and 148. There's nothing ambiguous about that question. And if there were, Mr. McLaughlin had the opportunity to object and had the opportunity to ask questions at the end of the deposition to clarify that response, should he have felt it was ambiguous. The meaning of cause is the same in general nomenclature as it is in the law. And Dr. Bushman was a retained expert. Ahead of his deposition, Mr. McLaughlin had the time to meet with him and confer with him on his opinions and explain what causation in West Virginia, if he felt it was different from a legal context, is. But he still, Dr. Bushman responded that there was no causation in regard to the form consent process.
What is the recovery that is possible if there is a failure to do an appropriate informed consent? What do you recover? What does an inappropriate informed consent, what would be the damages that could be recovered because of that?
It would depend on the expert testimony. What does the expert say that the damages are? In this case, the expert said that there's no causation to the damage of the wet tap. We're talking about two different things. The informed...
Yeah, and that's an interesting point that you make, because my review of the record indicates that she had the right, if she had known that the student was going to participate and said no, then there was only a 1 to 3% chance that she was going to have a wet tap, right?
Correct.
And if she had said yes and the student can participate, she would have known that there was a 20 to 25% chance she was going to have a wet tap, right?
So Dr. Bushman testified that the standard of care did not require Dr. Bragg to tell her that there was a higher risk with a student involved. So had Dr. Bragg said there's a student involved, that's all he had to tell her. He didn't have to say, and as a result, there's a higher risk of wet tap. Dr. Bushman was clear on that during his deposition, that he didn't have to do that. Because if you think about it from a public policy standpoint, if you say, hey, there's a student involved and the risk of a wet tap is higher, who's going to agree to that? Nobody. So Dr. Bushman was clear that the process of informed consent, he had to tell her that there was going to be a student actually performing the procedure, but he didn't have to go so far as to say the risk would be higher.
So go back to my original question. What would be the damages to be recovered from an inappropriate informed consent?
I don't think there is one. I think that the medical negligence case is part of the informed consent claim, right? And without a medical negligence case, do we even have an informed consent case?
Well, I mean, I guess, I've been thinking and trying to work on it, and even though it was not medical negligence, the wet tap did not constitute medical negligence, and I think that's not appealed. That's a finding, essentially a finding in this case.
Correct.
So if she was not given appropriate informed consent that the student was going to participate, then effectively the student battered her.
Right.
I mean, it would be battery because the student had no right to touch her in any way.
That would be, so in getting prepared for today, there's two types of informed consent cases, one that goes along with battery and one that goes along with medical negligence. Battery has never been pled in this case.
Never been pled in this case.
Yeah, only medical negligence.
Okay.
And if you review the court's last several cases on informed consent, they all have to do with underlying medical negligence. There's always a medical negligence claim that gets to the jury.
Counsel, obviously petitioner suggests that the circuit judge got the standard wrong in the issues on proximate cause. How do you address the Adams-Elbash standard in West Virginia law if a reasonable person in the patient's circumstances would have refused the consent to the surgery had the risks been properly disclosed? Obviously, you think the circuit judge got it right, but how do you get over the Adams standard in West Virginia?
I don't think this case exactly fits into the Adams case. So the Adams case, there were, things that had to be disclosed, and one of those were risks. Mrs. Schaefer testified that she was aware of the risks. She signed the consent form that listed the risk on there. I think the plaintiff's expert agreed that Dr. Bragg appropriately told her what the risks were. So it's a little bit different than that case, this one, because Dr. Bragg actually goes through the risks with her. She knew what they were. She knew a headache was part of the risk of the procedure. So there's still, though, in the Adams case that a causal relationship must be established between the failure to disclose the information and the damage to the patient, which, going back to that one question answer that I asked Dr. Bushman, he does not make that connection. He talks a lot about the student's participation and why he believes that led to the wet tap. And what he believes is that my client needed to remove the epidural needle and restart. Then he would have known where he was in the patient's anatomy. But he testified that he didn't believe the standard of care required that it was a physician preference, and that while he would have restarted the procedure, there was no standard of care that required my client to restart the procedure. Just real quick, because I want to leave Mr. Offit some time. The screening certificate of merit in this case, one of the allegations is that that was disregarded by the circuit court improperly. Screening certificate of merits under 55-7B6 subsection J are clearly confidential and not admissible in any court proceeding.
Haven't you waived that, though? It got attached and got admitted in the record. Haven't you waived that objection?
So even if we have, the certificate of merits are not different than Dr. Bushman's deposition testimony. So I had them, obviously, when I deposed him, and it's a roadmap for me as I go through step by step through his testimony. The certificate of merits are not different. And if you notice in the petitioner's petition and the reply, he never directs you to a specific sentence that contradicts that one question answer that he claims is ambiguous. The certificate of merits talk a lot about removing the epidural needle and restarting the procedure. But again, that was part of the medical negligence claim that was in the case at the time. Even if we'd waived it, which I don't, I think still that they are not admissible, but even if we did, it's not inconsistent with his deposition testimony. It's the same. So, overall, the plaintiff has not proven that there is a causal relationship between the informed consent process and the wet tap that occurred. Because the petitioner has not proven that causal relationship, there's no material fact at issue, and the Circuit Court of Kanawha County was correct in granting summary judgment in this case. Thank you.
Thank you.
Chief Justice Armstead, Justices of the Court, my name is D.C. Offutt. I represent CMC in this case, and I'll try to be brief and not repeat things that Ms. Malone has handled quite well, I think. I want to start just as a point of explanation here. CMC is a teaching hospital. The CRNA program has been around for over 50 years. It's affiliated with Marshall University, and graduates of that program receive a PhD from Marshall. It's a certified and accredited program. And more than half of the CRNAs that practice in this state went through that program. It's the only one in the state. And I think that you need to understand that CMC has residents, med students, student nurses, student technologists, CRNAs, all kinds of procedures going through at the hospital every day. So we provide a general consent form that students may participate in their medical care. But it's up to each physician as to how they're going to use that training. For example, the anesthesiologists in this case are all independent from the hospital. They're not employees of the hospital. They agree to participate in the training program, but each may do it in a different way. Some anesthesiologists may feel comfortable in only having the student there and watch them as they explain. Another may let the student put their student's hands on his hands or her hands as they put in the needle. Others may feel comfortable letting the student, as in this case, start the needle and then finish the procedure themselves, so it varies. So that's why the consent forms are different, and why the consent for the procedure itself, it would be up to the surgeon to say a student's going to participate in it and actually going to place the needle. Clearly, Ms. Schaefer knew that students were participating in her epidural. She signed the consent form when she pre-admitted. The student, it's undisputed, the student came in and introduced himself to her before Dr. Bright got there and went over several things with her over many minutes. She admits that he was there as the epidural was done, although the epidural was done behind her back. She never complained about that at all. Her only complaint before this suit was filed is she didn't think she should be charged for the blood patch procedures because a student had caused the epidural puncture. So when she filed that grievance, which is a process required by the federal regulations regarding health care and federally funded programs, CMC did an investigation and concluded that the student CRNA did not cause the wet tap, but decided that she had been probably misinformed about where to go if she had complications after the procedure, and so she presented to the emergency room instead of the anesthesia holding area. If she would have come back to anesthesia, she wouldn't have been charged at all for this procedure. It would have been considered part of the original epidural. So CMC agreed to waive the charges and not charge her for that. But when the hospital administrator sent her a letter and said a student was not involved in the epidural, she was mistaken. She should have said a student didn't cause the epidural, and Ms. Schaefer says she suffered great distress over that. I mean, she might have been embarrassed or upset, but it certainly doesn't rise to the intentional tort of outrage that they're tried to raise for the first time on this appeal. And we believe that that wasn't properly preserved or pled at the trial court level. I think Judge King got this right. I think this is a summary judgment that this court should affirm, and unless the court has any questions, I'll waive the rest of my time.
All right. I don't believe there are any questions. Thank you.
I'm going to start at the back, and I'll start where if you want me to start, but I'm going to start at the back.
what Mr. Offer just said, that this was raised for the first time on appeal. The tort of outrage was very clearly specified as, in response to the summary judgment motion, was very clearly identified as a claim that was being pursued. The judge very clearly said, no, you can't pursue it. It's raised for the first time on this appeal the other way, that we didn't plead it properly, and had they raised it below, we could have amended our pleading at any time. It was clearly part of the case from the very beginning. Most of the discovery that took place in this case focused on the conduct of lying by CAMC throughout the post-epidural procedure, and continued into this case. So after they received the notice of claim, they got an affidavit from Mr. Chapman and said, my whole time at CAMC, I never put my hands on an epidural needle while I was on the patient's back. Then Dr. Bragg testified that he did. So when they say that she must have known that he was there to do this, rather than just to do the things that he said in his affidavit, that would be, I might say that makes sense, and I wouldn't agree with it as a legal point or legal conclusion to follow from it. It might make sense for Dr. Bragg's counsel to say it. It doesn't make sense for CAMC's counsel to say it, because CAMC took the position even at the outset of this case that he didn't have his hands on the needle. As to a causation, again, I just want to say that throughout the case, from the addendum to, I went back after Ms. Malone said that the addendum doesn't specifically say that there was a causal connection between the student's participation in the wet tap and the epidural wet tap. It does. It says it very clearly. And he said in his deposition very clearly, the only thing, if you go through the standards for an informed consent case, get informed consent. If you give informed consent, does the person have the right to refuse? That's a jury question. That whole set of inquiry about whether she would have refused had she been told, and I'll agree with I agree with Ms. Malone that there's no testimony that they had to say there's a 20% chance. But she had to say that the trainee is involved. And the patients themselves can reasonably know, and in Ms. Schaefer's case, she says, if I had been told, I would never have let somebody put a trainee take a needle to my back. I'm afraid of needles, I would not have done that, and I do that, and do that. Now, that's a jury question under West Virginia law, whether she should be believed or whether it's reasonable for her to take that position. Those are jury questions. And there's no question that we can make those, that both sides can argue that, and that's for the jury to decide. But back to what Justice Hutchison, you were saying, that it is true that if she had refused the epidural, then instead of having a 20 or 25 in 100 chance of getting a wet tap, she would have had a 1 or 3 in 100 chance of getting a wet tap. And if we go back to, when we remember, we didn't get to this point in this case. There were no doubt motions filed, no challenges, anything like that. If we go back to that, it's ordinarily a doubling of the risk. Well, 3 to 20, if you take the highest risk possible with an experienced anesthesiologist, and the lowest risk that is in the record for a trainee of Dr. Chapman's, Mr. Chapman's experience, of 20, that's 6 2/3 times. So it's quite a bit of an increase in the risk. And that's the actual causation right there, is that she was denied the opportunity to say, I don't want this trainee to participate. Whether she would have been reasonable for denying that is a jury question. Whether she would have denied, whether she would have said that is a jury question. The jury doesn't have to believe her. But then, had she said that, had it been done by Dr. Bragg from the beginning to the end, our expert clearly said there's a 20, as Justice Hutchison said, 20 or 25 out of 100 of these will end, instead of that, 1 or 3 in 100 will end in like that. There were some other things that I put in the brief that we didn't really get to. I don't need to, I suppose. But thank you.
All right, thank you very much. This case will be submitted.
The next case for oral argument is also being charged under Rule 20, West Virginia Regional Jail and Correctional Facility Authority and others versus Grove. Docket numbers 18-1076 and 18-1083. Appeals from the Circuit Court of Raleigh County, West Virginia. And I will let counsel know that although Justice Workman is not here in the courtroom, she is participating by observing the webcast, and so she will be participating in the decision and opinion in this case. I'll remind you that each side has 20 minutes to present oral argument, and we've added a clock right there to the left of the podium that you will be arguing from, so that you can keep track of your time. And I will remove the microphone over that was left there, and then you can put yours up there if you want to remove your mask, and then please take it off when you finish.
Good morning. As you're preparing, we'll just, if you certainly have the option if you want to leave your mask on as you speak, or if you'd rather remove it while you're speaking with the court, you certainly may do either. And just would remind both petitioners that you have 20 minutes combined, so hopefully you've decided among yourselves how you want to split that up. Okay, thank you.
If it pleases the court, my name is Matt Whitler. I am here on behalf of the petitioner, West Virginia Regional Jail and Correctional Facility Authority. Mr. Marshall and I will divide our 20 minutes equally, and I reserve 2 minutes for a rebuttal, 2 minutes of my 10 minutes for a rebuttal. The Circuit Court's order denying the Regional Jail Authority's motion to dismiss is defective in a number of grounds as outlined in our brief and also our reply brief. The court has already granted defendant Prime Care's writ of prohibition in the same matter based upon the same amended complaint that we hear about today. The grounds for that was based on the Medical Professional Liability Act, which doesn't apply to the Regional Jail Authority. However, the Circuit Court used the same template for its orders denying the motion to dismiss to all 3 defendants, and thereby failed to apply standards that the Regional Jail Authority as a state agency requires. Initially, as the state of Mr. Grove has conceded that the Regional Jail Authority is a state agency not subject to punitive damages, as initially was argued and was not granted in our motion to dismiss by the Circuit Court, it is clear that the Circuit Court's order must be reversed at a minimum on these grounds. The record is also clear that the Circuit Court did not apply the heightened pleading standard as demanded by the holdings in Hutchison v. City of Huntington in suits against entities or individuals that can assert the defense of statutory or qualified immunity. In its motion to dismiss, the Regional Jail Authority asserted qualified immunity and heightened pleading in its motion to dismiss, but there's zero analysis in the order from the Circuit Court as to the heightened pleading standard. In only 2 paragraphs that specifically dealt with the Regional Jail Authority's arguments that's contained within the order, the Circuit Court merely said that the plaintiff set forth sufficient facts and didn't state what facts those were, and noted in its ruling from the bench, which is cited in our brief, after oral arguments, that the Circuit Court wanted to see what the development of evidence is before granting any motion to dismiss. Therefore, it's not following the proper procedure and the proper law for a motion to dismiss, let alone a claim against a state agency. Furthermore, the Circuit Court utilized a reasonably prudent person standard as to allegations of the protocols at the regional jail. Without the analysis required under the heightened pleading standard, the Regional Jail Authority was denied the protections under Hutchison for the Circuit Court's analysis of the Rule 12 motion as to the various counts of the amended complaint against the Regional Jail Authority. Instead, the rigor that's installed in the heightened pleading standard, this reasonably prudent person standard that the circuit court used led to a complete lack of evaluation of the various counts that the plaintiff has against the Regional Jail Authority. If we move into what's the immunity issues that were raised by the Regional Jail Authority, the dismissal should have been proper back at the circuit court level. As this court is aware, executive or administrative policy-making acts by the state agency are immune. Furthermore, discretionary government functions, the reviewing court must determine whether the plaintiff has demonstrated that such acts or violations, omissions are in violation of clearly established statutory or constitutional rights of which a reasonable person should have known or were otherwise fraudulent, malicious, or oppressive. The plaintiff made several allegations against the Regional Jail Authority as to the suicide that occurred by Mr. Grove. He alleged that there was a failure to properly hire correctional officers, duty to train correctional officers, failure to retain correctional officers, duty to supervise correctional officers, a duty to provide a safe and secure confinement facility, and also a failure to place Mr. Grove on suicide watch. However, in the amended complaint, there is not one claimed fact that supports these allegations. It is very much a very broad notice pleading standard, which is not in accordance with the heightened pleading standard that the law requires. Nor is there any allegations of how the Regional Jail Authority violated any of these duties through its maintaining Mr. Grove in the medical watch facility that he was in. The AB case, which is cited in our brief, provides a roadmap for the court to evaluate this failure for the circuit court to look at the immunity issues. Immunity is proper for the discretionary functions of hiring, firing, training, and supervising employees. Adoption of policies or procedures is an administrative or executive act, which is also immune. Finally, the monitoring of inmates should be evaluated under the Moats versus Preston City Commission case, in that those acts were found to be discretionary. Now, we will acknowledge that that case did find that on the issue of suicide, there is an exception. However, that case stated clearly that the jail had to know that there was a potential for suicide existed in this matter. It was not pled in the complaint at all that there was specific knowledge and of a specific suicide threat to Mr. Grove. It was a very broad, he was in jail, he committed suicide, therefore the jail is at fault.
That seems to be a little bit of a point of confusion in everything here. Was he on suicide watch, or is the contention he should have been on suicide?
I believe he was not on suicide watch, Your Honor. I think the contention may have been that he should have been. The way it works is that Prime Care evaluates each person individually as they come into the jail. They do a medical check. Part of that medical check is also doing a suicide evaluation of their mental health. If they are found to be in mental health, they're a threat to themselves, they're placed in suicide watch, which is a separate facility in which they are not provided any items of clothing that could be of threat. They're monitored on 15-minute cycles. He was at the jail for 4 days and was placed into the medical facility, the medical wing, because of having withdrawals from opioid addiction. So he was having withdrawals. They placed him in that facility. So he was not on suicide watch. Furthermore, there's no regulation that places a duty onto the jail or its employees to make an evaluation as to whether that person is suicidal. They just don't have the training for that. That's why there is outside medical staff who makes that evaluation. We would argue this court that not only was the failure to apply the correct standard of review reversible error, but that when the discretionary immunity analysis applied to the Regional Jail Authority in this matter, find that they should be dismissed from this action. And I will pass my time on to Mr. Marshall.
I'm not going to reiterate too much of what Mr. Whitler just said. My issue is more focused on the actual act that's pled in the complaint. The single act that Mr. Taylor and his client have alleged is that my client missed a security check and that somehow resulted in the suicide of the plaintiff. As Mr. Whitler just explained, they had no knowledge that he was suicidal in the first place. Apparently he went through the checks in the medical facility. Then he was put on general populations. What my understanding was, he started going through withdrawal, and they put him into the medical unit for observation due to withdrawal. There was no indication that he was suicidal, or no indication, and nothing that would have put my client on notice that he was suicidal. Now, the allegation that he missed a security check is the only factual allegation in the complaint as to what he did. Everything else is conclusory that constitutional rights were violated. It's not how the safety check caused anything, what rule that violated, what particularized showing that makes is not included in the complaint. With, as you know, with qualified immunity, you have to show that a constitutional or statutory right was violated, and that it was something that a reasonable officer would have known. Well, he hasn't cited to any constitutional right or statutory right that was violated by not doing this one safety check. It's not pled that he missed any other safety checks. There's no evidence that he did miss any other safety checks. And the point is that there is nothing in the rules, in the statute, in the Constitution, or anything that entitles an incarcerated person at the jail to a safety check. It's just not written anywhere, and the plaintiff has not cited to anything showing that he violated anything by not conducting this safety check. Now, he's going to make arguments that this somehow violated the code of conduct, which is fine, but that's not the particularized showing that you need in order to overcome the immunity afforded to my client. The fact of the matter is there was no constitutional right that was violated by missing the safety check. He just doesn't have it. It's not a constitutional right. And not to mention the fact, while it's tragic, the suicide itself is the superseding intervening cause of this incident. I mean, it's sad, but the plaintiff took his own life. That's an intentional act that oversees anything else that my client has done. It would be a different story if he had been on suicide watch, I think, because there are specific regulations as to what you're supposed to do if there is somebody that is known to be suicidal in the jail. In this instance, he was not. Therefore, there cannot be any statutory or constitutional right violated by my client because the plaintiff's, because the respondent or the estate of the respondent committed suicide. Just to note on the order as well, the order is deficient, as Mr. Whitler explained, as far as what the pleading standards are for cases involving immunities. It's pretty clear that you need to identify a particularized constitutional or statutory right that's been violated. You also need to provide facts that support that constitutional right or statutory right was violated. The complaint does not have any of those things. They're all conclusory allegations except for that one statement of fact that my client missed a safety check. And there's no rule, particularized statutory rule or constitutional right that's violated as a result of missing that safety check. The other thing to point out is that we're asking that the court send this back to the circuit court with directive to dismiss the case in its entirety. I believe that the reason that the circuit court could not make the particularized showing in its order denying its dismiss is because it's simply not pled. And the court wants, in the order to dismiss, it said it wanted to see more evidence, but that defeats the immunity. The purpose of the immunity is to protect state officials and the state itself from having to go through litigation and go through trial unless there is a particularized showing to justify it. And the respondent has not made that showing in this matter, so accordingly it needs to be dismissed. At this point, I don't have anything further. Thank you.
Thank you.
May it please the court, good morning. My name is Taylor. I'm happy to have traveled down from Martinsburg to represent the respondent, estate of Cody Grove. There are 3 points I'd like to have an opportunity to make today. First, that we met the Rule 12b-6 standard. Second, that qualified immunity is not applicable under the current facts of this case. And perhaps importantly, qualified immunity in its current form and in its current application is subject to abuse and misapplication by state actors. With the court's permission, I'll have a chance to rebut some of the argument that we've heard this morning. The first point, we met the Rule 12b-6 standard. All we are required to do is set forth sufficient facts in the complaint to provide notice to the defendant of why they're being sued. We are required to, and what we did, demonstrate, I think, in the supplemental appendix that the court permitted to be filed, is demonstrate that there are ample facts and legal theories, and in fact additional legal theories upon which this complaint is based and hopefully will be based if this court remands this case to the Circuit Court of Berkeley County for further proceedings. We've set forth multiple theories of recovery in the complaint. That's all we have to do to meet the 12b-6 standard. It's not a summary judgment standard, it's a notice standard, and we've met that. This court's jurisprudence has always viewed Rule 12b-6 motions to dismiss with disfavor. Many of this court's qualified immunity opinions are based on cases that reach the summary judgment stage of the proceedings. In other words, there was an ample opportunity to engage in discovery before summary judgment was or was not entered by the circuit court. Part of the misapplication of this qualified immunity standard is an attempt by state actors to confuse these standards, the 12b-6 standard, which just requires notice, and the Rule 56 standard, which requires no genuine dispute of material facts. We haven't had a chance.
How do you get around, though, our line of cases that deal with qualified immunity, and we've written several here in the last couple of years?
Yes.
How do you get around the requirement that those cases, if it involves potential qualified immunity, you do have a heightened pleading standard, not notice, not our rules of civil procedure, notice provisions, but in those cases you have a heightened requirement. How do you get around that in this case?
The petitioners have hung their hat in part on that language that comes from the Hutchison case. And in that opinion authored by Justice Cleckley, he calls heightened pleading, and I quote, a misnomer. We are not required to anticipate the defense of qualified immunity when we file our complaint. That's language right out of Hutchison. Justice Cleckley indicates that the better practice is to permit or require a Rule 12e motion for a more definite statement. If a defendant doesn't understand why they're being sued, they can file a motion under Rule 12e and ask for a definite statement. That comes right out of Hutchison. It wasn't done here. Hutchison also says that if you plead your best case as you understand it at the time of the filing of the complaint, that's sufficient. And the early motion to dismiss, which is what we have here, should be denied. All that language comes right out of the Hutchison case. So Hutchison really kind of cuts both ways. Really, in my opinion, I think it helps us more than hurts us for the reasons that I just mentioned. The second point I wanted to make is that qualified immunity is not applicable under the current set of facts as we understand them. Former corrections officer Zombro, by act and omission, stripped himself of qualified immunity, and through the doctrine of respondeat superior, the regional jail authority is also stripped of qualified immunity. The supplemental appendix demonstrates that Zombro was plainly incompetent. He had been disciplined for not following the simple act of locking a cell door in the very same medical unit where a couple months later Cody Grove was allowed to hang himself, because Zombro, further demonstrating his incompetence, did not perform a required safety check at the required point in time. The guy was plainly incompetent. He quit his job right after this incident. He lied during the internal investigation. He falsified the log. All that information you'll find in the supplemental appendix to demonstrate that this former corrections officer was incompetent. He knew he violated the law. That's why he forged the log. That's why he lied during the internal investigation into Grove's death. He knew he was wrong. He knew he broke the law. He knew he violated procedures and regulations of the Regional Jail Authority. That's why he tried to cover his tracks.
Counsel, you said he knew he broke the law and he knew he violated the regulations, and those are two separate things, I think, that go to the heart of the question here. What is the specific statutory or constitutional requirement that you allege he violated?
I believe it's Hutchinson. The court indicates that due process is violated when a state agency does not follow its own rules and regulations. That's the constitutional violation here. In addition to statutory and regulatory violations, that is the constitutional violation. We, as citizens, Grove, as a citizen, had a right to have the jail authority and its employees follow their own rules and regulations. That's the due process violation here.
Was there a specific regulation that said when they would make these checks?
If Your Honor looks at the log sheet,
Specific as to requiring
it's supposed to be at a certain, excuse me, I didn't mean to cut you off, sir. It's supposed to be on a regular basis. If you're on suicide watch, and this goes to the question that was raised by Justice Hutchinson, if you're on suicide watch, the regular checks are more frequent. If you're on a heightened watch, they're not as frequent, but they must be done, and there is a log that you must complete with the time, the name of the person that you're checking in on, and that sort of thing. So really, it's kind of a distinction without a difference, whether you're on suicide watch, heightened watch, or opioid withdrawal watch. You must be regularly checked. There's a log that you fill out. Zombro falsified that log. You will find that in the supplemental appendix.
But again, I don't mean to belabor this, but when you say a regular basis, is there a specific time listed in any regulation you can point to and say you must do it this often, or is the term regular basis what you're referring to?
I can't cite, Your Honor, to verb and passage of what this regulation would be, but it is a policy of the Regional Jail Authority. He was tasked with doing that, and he didn't do it. There's a log sheet that he's supposed to fill out. He falsified it. So I can't give Your Honor chapter and verse of what this policy or regulation is, but it's there, and it's a ministerial act.
Let me ask you.
Yes, sir.
And I think what the Chief is trying to get to, and I as well, when you say it is there, obviously you've referenced multiple times the log sheet, but when you say it is there, where is that policy written down in a manual or some policy statement that says these checks must be done on a whatever basis?
This is the disadvantage that people in Cody Grove's position have when they're faced with an early motion to dismiss under qualified immunity, when there has not been a sufficient opportunity to engage in discovery, depose Zombro, depose his superior officer. Long story short, I can't answer the Chief.
So when you
I
say
can't answer
it
the
is
Justice.
there, you believe it is there, but you have not been able to show that it is there at this point.
I believe Your Honor will find the answer to that question in the supplemental appendix, not only in the log form that I mentioned, but in the internal investigation, where the facts, such as the one that Your Honor is focusing on, are developed in that investigation. It's pretty clear in the report on Grove's death that Zombro missed a required check and then tried to cover it up. I think that's where Your Honor will find the answer to that question. So another exception to qualified immunity is if the actor is performing a ministerial act. And I submit to this court that performing regular safety checks, which is what jail guards are required to do, is a ministerial act. There's no discretion. You lock that cell door. You perform the checks that you've been ordered to perform. If you don't, you will lose your job, you will be disciplined. You have no discretion whether or not to turn that key or look in that cell. A good analogy is an enlisted person in the military. The military is a good analogy here. Remember, the Regional Jail Authority is a component of the Department of Military Affairs. So there's a pretty close analogy here. These jail guards wear uniforms. There are ranks. There is a chain of command. There are orders in place, and you have no discretion as to the performance of your ministerial function. That is an exception, another exception to qualified immunity. I mentioned that violation of clearly established statutory or constitutional rights also constitute an exception to qualified immunity. Under the Administrative Procedures Act, the regulations that control the conduct of the Regional Jail Authority's business carry the weight of statute and law. The third point I wanted to make is that qualified immunity in its current form and its current application is subject to abuse and misapplication. And I use the Justice's question about where can I find chapter and verse of this regulation that's been violated. Well, I can't answer you because I never got a chance to engage in discovery. But the best answer I can give is if you look at the report of the death of Cody Grove and the other documents in the supplemental appendix, you will find your answer by implication, if nothing else. Another form of misapplication of the qualified immunity doctrine is the confusion of the two standards that I mentioned. Rule 12b-6, we just have to set forth sufficient facts and sufficient theories of relief to proceed forward on our complaint. That was Rule 12b-6. Rule 56 summary judgment is much more rigid, and there has to be an absence of an issue involving material facts. And that's what's being done here. It was a summary judgment that there's enough to proceed. But what the petitioners want this court to do is apply a Rule 56 standard when it really doesn't apply. There should not be a rush to a summary ruling without the benefit of discovery. Circuit courts should not be prevented from deferring ruling on qualified immunity or making an interlocutory ruling on qualified immunity without the benefit of factual development through discovery. We pled our best case, and at page 660 of the Hutchison opinion, nothing more is required for us to proceed.
Counsel, do you believe there's an issue with the lower court's order of providing no analysis relating to qualified immunity, that at a minimum this should go back and have such analysis conducted?
I think it would be wonderful if this court issued an opinion that modifies qualified immunity to permit true development of the facts surrounding the issue through a course of discovery. In answer to the court's question, yes, that would be wonderful for the case to be remanded for further factual development, but that's done through a course of discovery. And that's one of our complaints here, that this appeal that's before the court this morning really is premature. It's a rush by state actors to get this court to make a knee-jerk ruling without the benefit of factual development through discovery. So we would welcome remand, but with further refinement of the qualified immunity doctrine to at least permit circuit courts to have the information necessary from discovery to make a fully informed ruling. And it benefits this court too. This court can't make a fully informed ruling without the benefit of a course of discovery. Let me just very briefly rebut the argument of my co-counsel here. The issue of prime care's dismissal, without prejudice, by the way, is irrelevant for purposes of this hearing today. Prime care was dismissed without prejudice because of noncompliance with the medical malpractice statute, an entirely different issue. It's a mechanism to distract this court from the real issues here. As I mentioned in response to the Justice's question, heightened pleading is not required here. It's a misnomer. That's a quote out of that opinion. I've mentioned Rule 12e. That's it. This distinction between suicide watch, withdrawal watch, or heightened watch is really a distinction without a difference. They all require regular safety checks. They all require truthful completion of the log by the person performing those checks. And unless the court has further questions, I'm going to stop now. Thank you for your consideration.
All right. Thank you very much. Is there a rebuttal?
Very briefly, Your Honors, the Justice is correct that the respondent is attempting to use a Rule 12 notice pleading standard in this matter, which just does not apply. It does not apply whether they filed Rule 12 or not. If the court has to analyze it using a heightened pleading standard, that's the law, and the circuit court failed to do that in this matter. The question of whether we should have applied for a Rule 12E motion, that E is only if the complaint is so vague that the party cannot reasonably be required to frame a responsive pleading. That was not the issue of vagueness. We could easily file a responsive pleading, which we did. The question is that the failure to apply the proper legal standard, both to the complaint and then, of course, in the resulting circuit court order, which leads us here today. The issues concerning attempts to modify the qualified immunity issue, if the standard had been correctly applied, the regional jail authority should have been dismissed in this matter. There is no basis for the law being changed at this time. This court has applied a long litany of cases that properly spell out what litigants are supposed to do in this matter, and honestly, it was not followed in this case. Therefore, I'll cede the rest of my time to Mr. Marshall and urge that this matter be remanded for dismissal. Thank you very much.
Just before you leave the podium, Justice Jenkins had mentioned the sufficiency of the findings in the circuit court's order. Do you believe that it is fairly sparse? Do you believe that they are sufficient to justify a finding of qualified immunity? Or?
The findings themselves are not, Your Honor, and they're clearly not, because they don't go into any of the analysis that the court requires for the circuit court in a qualified immunity matter. I think this court could look at it and find that the facts are sufficient enough that the regional jail authority should be dismissed in this matter based on the bare bone allegations against it and the lack of factual support behind those allegations within the amended complaint. But I think that would have to be at a minimum what would potentially, if the court does decide to remand the case for further findings, it is needed because that order is deficient. We feel that it shouldn't be remanded, it should be dismissed at this point. But yes, Your Honor, I believe that order is lacking in any of the analysis that's required under the legal standards.
And the status of discovery, obviously, I've raised the question, and counsel says effectively let this continue so they can try to find some documentation, a written policy. obviously he believes the there is there. What is the status of discovery, and has there been an effort to identify such policies and whether or not they exist?
There was some initial FOIA requests that were responded to. That is where discovery has stood. We followed the rulings from the court that if you have a state agency that's being sued, they're entitled to find out whether this matter should be dismissed before getting into the various discovery issues that can come up with, especially this matter. It was not premature to file the motion to dismiss because the law is clear that state actors and the agencies themselves should not have to go through unnecessary discovery in some sort of fishing expedition to find it out. This case was filed almost at the eve of the statute of limitations. There's 2 years that went by where there could have been discovery. Information could have been requested by the estate on Mr. Grove's medical condition. A lot could have been done, and yet we get to the eve of the statute of limitations, he files this complaint. And he's also had a second bite at the apple because he's filed an amended complaint, and yet we're still.
Obviously, we've got the suggestion that there's a difference of opinion on what the holding in Hutchison really means, and the Cleckley reference that the respondent points to in that opinion. Subsequent to the Hutchison, what case law in West Virginia do you think clarifies the heightened pleading standard that you're suggesting? I think the AB case really spells out the requirements of of qualified immunity, in that it looks at all the various administrative, executive, and the adoption of policies. There's been talk by the respondent counsel about adoption of the requirements to go through and view Mr. Grove. That, once again, falls clearly under the qualified immunity standard for policies and procedure adoptions are immune. So I think that the case law is clear for the court to make the analysis that this the amended complaint doesn't follow through with the requirements needed to defeat the claims of qualified immunity for the Regional Jail Authority.
All right.
Thank you, Your Honor.
I think it's important to note that in this matter, the plaintiff had two opportunities to plead this case when we talk about a heightened pleading standard. He pled the original complaint that contained no facts at all as to what my client did, filed a motion to amend, and then amended and added in that my client missed a security check. He could not identify a constitutional right that was violated. He could not identify a statutory right that was violated. Justice Jenkins was asking about specific policies and that the plaintiff needs discovery in order to uncover those policies. Well, an internal policy does not arise to the level of a constitutional right or a statutory right. Those are internal policies. If the policy was a statutory or in the CSR, that would be a different story. It's not. These security checks are just a policy, and they're, as you said, regularly. They're discretionary as to how they're going to be conducted. They try to conduct them every hour. They don't always get to them every hour because there are other functions of their jobs. And for an example, if there was an emergency in another part of the jail, they're going to respond to the emergency before they get to the security check in the medical unit. Not only that, but they have discretion into what they see in the medical unit as to what course of action they're going to take. These are not ministerial duties. So we would just ask that the court send this back with instructions to dismiss the case because, as you asked, does the court justify a finding of qualified immunity? I think it absolutely does because it can't point out any facts or any facts to support a violation of a constitutional right or a statutory right, nor can it point out the constitutional right or statutory right that was violated by those facts. Thank you very much.
Thank you. All right, thank you. This case will be submitted.
The next case for oral argument is also presented under Rule 20. Scott Vincent and the Clarksburg City Police Department versus Rosa Lee Butcher, docket number 190132, an appeal from the Circuit Court of Harrison County, West Virginia. And I would like to let council know that although Justice Workman isn't here in the courtroom today, she is participating by viewing and listening to the oral argument, and so she will be participating in the decision and opinion in this case. I'll remind you that each side has 20 minutes to present your oral argument, and we have put a clock right to the left of the podium that you'll be arguing from so that you can monitor your own time. And with that, counsel, the petitioner may proceed.
And to counsel, if you, once you have your microphone cover on, if you may remove your mask while you're addressing the court or leave it on, whichever you prefer.
Okay. Thank you, Chief Justice. And may it please the court, my name is Matt L. Shoddy, and I'm here today representing the petitioners in this matter, which includes the City of Clarksburg, which is inclusive of the City of Clarksburg Police Department, and named officer Scott Vincent. At this time, I'd like to reserve 5 minutes for rebuttal, if that's agreeable. Thank you.
You may just watch your time there and make sure you leave that much time.
Thank you. Petitioners respectfully ask this court to reverse the Circuit Court's orders which attempt to inappropriately allocate liability and damages against petitioners, and we ask that they hold, that this court hold, that John Does are not appropriate parties in a 1983 claim for excessive force, and because the jury in this case found only John Doe responsible for respondent's claim, the respondent has failed to prevail on her claims. Now, we seek a reversal for two central reasons. The first being that 1983 jurisprudence does not allow for liability to be assessed based on vicarious liability or respondeat superior principles. And it further requires a showing of personal involvement of individuals who allegedly deprived the claimant of her constitutional rights. And in this case, the respondent has failed to make that showing. And the second central reason is because allocating liability and damages against dismissed parties or non-parties as a result of a verdict solely against John Does allowed the respondent to disregard her burdens to timely name proper parties in her suit within the statute of limitations. Because it's probably helpful and relevant, I can briefly go through a timeline, if that's beneficial to the court, or I can skip right to my argument.
It's certainly up to you, but I believe that we're familiar with the general facts of the case, so if you want to proceed to your
Absolutely.
You may do so.
At its core, this is a case that's always been about whether or not John Does are proper parties to a 1983 claim. But as a result of the Circuit Court's post-trial orders, which affirmed the jury's verdict against only John Does in the sole remaining claim in this case, which was a 1983 claim of excessive force, and granted respondent attorney fees stemming from that. Because of that, petitioners are being assessed an improper reallocation of liability, which acts to attempt to shift liability or responsibility for paying a judgment to a dismissed or non-party in the sake of the City of Clarksburg or its insurance carrier.
The City of Clarksburg was dismissed prior to trial, is that correct?
That is correct.
And then the jury found that the defendant, Vincent, was not responsible for the plaintiff in that case, not responsible for her injuries. Is that right?
Correct again.
And so, is the judge in this case trying to say that because the jury found that John Doe was responsible, the city's got to pick up the costs?
Yes. That is our interpretation of the order, and it appears based upon an exchange between defense counsel at the time and the court while it was arguing its renewed motion for judgment as a matter of law after the close of all evidence. And in that argument, counsel was arguing for the dismissal of the city of Clarksburg based on a lack of evidence establishing a 1983 claim against the city itself. And in that exchange, the court asked counsel, hypothetically, if the city was dismissed and all that was left was Scott Vincent and John Doe, would they be left holding the bag? To which counsel responded, which the court reporter expertly caught my stuttering. The counsel responded, don't think it would be an issue. We've never argued that Scott Vincent or the named individuals were operating outside of the scope of their employment. Within the circuit court's orders, it cites to this exchange twice and saying that based on those assertions, insurance existed. Therefore, John Doe's could stand as the responsible party in this case, and as the judge said prior to this exchange, the city would be on the hook. And we obviously disagree with that. We disagree with it for many reasons. First, on the exchange itself. And with all respect to the circuit court and to the respondent, there seems to be a confusion about defense counsel's role in this case. Defense counsel was retained to look out for the interests and protect the interests of the insured, not the insurer. Under West Virginia law and the legal obligations and the ethical obligations, our duty is to the insured, and we have a duty not to jeopardize coverage or indemnities by some insurance policy. But more important than that, no dispositive ruling should come from that question. And again, respectfully to the court, it's a question that shouldn't have been asked. Coverage was never before the court. There was never a deck action in this case. The courts was never made aware of the policy or the language or any of that. Any dispositive ruling that came from the ability to collect on a judgment, rather than on whether or not the plaintiff has established the necessary elements of her claim, any decision of that nature is an error. And that's essentially why we're here today, because of those assertions made in the court's final orders, in both for the attorney fees and in the denial of our post-trial order.
Obviously, we've got a string of 1983 cases that, from my readings, say that individuals must be identified. And I think we anticipate from the respondent the suggestion that, obviously, at a very late stage, I did try to identify, but the court didn't allow us to do so. And I know from the petitioner, from your perspective, they had plenty of opportunity to identify during the process, but failed to seize those opportunities. Any comment about the, in anticipation of rebuttal to the respondent's suggestion, we tried, but the court didn't allow us to identify the John Doe?
Absolutely, and thank you, Justice. In response to that, there's a few things. I believe first and foremost is that, yes, they did attempt to amend on the third day of trial, which was 3.5 years after the statute of limitations had run, and again, in the middle of trial. Based on who was identified at that time, it was the same individuals that defense counsel had identified in discovery as being the individuals on duty that night. At least 2 of the same individuals were the same individuals identified pre-suit in a complaint filed with the city of Clarksburg itself by the respondent herself. But if we look at the trial testimony and we look at the deposition testimony, that's part of the record, respondent could still not identify who it was. She identified certain names. And it started with the pre-suit investigation. She said it might have been 2 people, and those were an Officer Lance and an Officer Harris. Then in her sworn deposition, she said it was Lance. Then at trial, that changed again. And it was, well, Lance might have been a witness to it. I don't think he actually did it. I think somebody else did it. I couldn't see who had the weapon. I couldn't see the weapon itself. I don't know who it was. Through her own admissions and in her brief, responds back that because of her poor recollection of that night, she can't recall who specifically committed the act. So even if they were amended at trial to allow those individuals, she still lacked the ability to show who was personally involved in the 1983 claim. And at the heart of a 1983 claim is this element of personal involvement. And that is settled by our Supreme Court, most often cited with Iqbal, where the court has said that because vicarious liability is inapplicable to these 1983 claims, a plaintiff must plead that each government official defendant, through the official's own individual actions, has violated the Constitution. Here, she could not identify who did it, even when she started to put names to the John Does.
Didn't she identify the exact person in her deposition?
She did.
But never added them.
Never added them. And looking at West Virginia law on amending complaints and Rule 15 and what stems from that, when we look at Muto v. Scott and we look at Brooks v. Eisenhood, we see things where, yes, there are times and rationale that allow for amendments and relation back to the date of the original complaint. But with those, there's some limitations, and a big part of that is, in order to substitute parties, the party has to have knowledge of it, but for some mistake. And when looking at that mistake element, this court has said that mistake can't be based on the dilatory conduct of the plaintiff. And in Brooks, went on even further and talked about how it cannot be some kind of strategic action on the part of the plaintiff. When we look at it here, to where that person, as Justice Hutchinson just said, that person's identified in the deposition, identified in discovery, identified pre-complaint, and still don't amend your complaint to name that person so that you can serve them and you can prosecute your claim and they can have their right to defend their claim. You still don't do that. That is absolutely the definition of dilatory conduct. And based on the respondent's own admissions through her briefings and her arguments that this was all based on her own poor recollection and it wasn't right, didn't feel it was right to name somebody, under that circumstance, how is it not considered strategic on her part to allow John Doe's to remain, where she can cast judgment or cast the suspicion of judgment any which way she wants, which we saw play out at trial when her theory changed. And it went from deposition, we believe it's Officer Lance, trial, well, Lance wasn't it. Now that I've seen the trial testimony. And that's an important point back to your question, Justice Jenkins, that the officers who testified at trial, which gave the respondent the opportunity to amend her complaint, the good faith basis to come forward and amend her complaint, all those officers were not deposed. Only limited discovery was done in this case, even though those officers, some of them, were identified as being on duty. The respondent also had taser logs. Every department-issued taser records each time it is deployed. Had the logs of every officer in the department. Even based on that, it's on the third day of trial, after trial testimony from these officers, that suddenly the good faith basis exists to amend. Suddenly the information exists to amend. That information was available long before then. And what this allows, and it's not just on counsel in representing these individuals, it's these individuals themselves. They have a right to be served, they have a right to be heard, they have a right to defend the claim as they see fit. And as brought up by, much more articulately than I did, by both of our amicus counsel who submitted briefs in this case. The issue is, where does this end? If you allow a petitioner or a plaintiff to wait to the very end of a case to finally name somebody, what does that do for all of our litigation? To where anybody can file a suit timely and then bring in somebody at the very end and say, this is who that person is. We're going to relate it back to 3.5 years ago, and now we're going to put them on the verdict. And I touched on this briefly, but I really want to stress the issue of her failure in this case to establish the personal involvement element. We cited, and unfortunately there's not too much on point in West Virginia, so we cited to some federal case law, which we hope helped frame the issue and looked at how this element plays out, I guess, in the real world. Two of the cases, one from the Third Circuit is a Drukowski case, and one from the Seventh Circuit is Colbert. And both with very similar fact patterns, to where 1983 action is alleged, and the individual plaintiffs in those cases, one being excessive force, one being destruction of property, I believe. They name 4 individual officers, but the plaintiffs can't say it was Officer A, B, or C who committed the act. The Third and Seventh Circuit in those cases, as well as the lower courts, had to dismiss those named officers because the plaintiffs could not establish the personal involvement of the government official in those claims. Here it's even more egregious. The individuals aren't even named, but even if they were, she lacks the information by her own admission at trial and in her arguments to identify who it was. And again, I would say the failure to amend, that's not, we're not arguing that the court got it wrong when it denied their motion to amend. What we're saying is that allowing a plaintiff to go that far and to not have to amend, what does that mean for our procedural rules regarding amendment and the precedent that stems from it? They're essentially meaningless if you can avoid them by just slapping John Doe on there and going all the way to verdict and then having the court say, John Does were found liable, therefore we're going to hold the dismissed party's insurance carrier liable to pay for that judgment. And for a lot of those reasons, our second point of error involves directly the attorney fees award in this case, and we're not arguing the amount or the discretion used by the court on that. But for many of the same reasons, the respondent in this case cannot be deemed to be a prevailing party if she doesn't have a judgment that can be enforced. And how she can enforce a judgment against John Doe's unknown parties, fictitious placeholders, it is not sound in the law, and the circuit court's attempt to essentially circumvent this issue by saying that insurance proceeds would be available is in error. And it goes against the clear policies on vicarious liability on a 1983 claim. And the court again cites to the insurance issue. And my last piece on that is all I would say is the court accused petitioners of being inconsistent in their positions. And in front of this court, I want to say we are not inconsistent. We've been very consistent in the fact that insurance coverage in this case is irrelevant. Court cannot make a dispositive ruling regarding the respondent's failure to establish a proper 1983 claim based on the existence or non-existence of insurance coverage. And based on that, petitioners again asked this court to reverse the circuit court's orders and to hold that John Does are not appropriate parties to a 1983 claim for excessive force. And because the jury in this case found only John Doe responsible for respondent's one claim of excessive force through 1983, the respondent has failed to prevail on her claims. And thank you.
Thank you. Okay, you may proceed.
Thank you. If it please the court, my name is Tim Gentilozzi. I'm here as the attorney for the respondent in this matter. Your Honors, what we're dealing with here is much different than the cases they've cited in their brief. If you go back and you review Jurtrowski case that they've cited as a precedent that a federal precedent that you have to name your John Doe defendant. In Jurtrowski, is very similar to this case in that there was 3 officers that were present the night the attack occurred. It would have been improper under Jurtrowski to name those 3 officers as named defendants in the case because we could not show any personal responsibility proven on any one individual. The respondent in this case, who was the plaintiff in the underlying case, was excessively drunk, excessive intoxication. Her intoxication level 2.5 hours after the attack occurred was .349 in the hospital. That was taken at the hospital in a blood draw. She had no under that level of intoxication, her credibility to recollect what happened that night when she went in and admitted in her initial internal investigation. She reported this to the police a year before the complaint was filed. She went in and told them, she said, one of these officers attacked me, but I don't know which one. I never even saw the weapon, because in her interview they asked her, what was the color of the weapon? Most of these tasers are bright yellow, but she couldn't tell them in the internal investigation what the weapon looked like because she admittedly never saw the weapon in their hand, in any individual's hand. She was so intoxicated that she remembered the attack, but not which one of them did it. And she's a 120-pound, 47-year-old woman in handcuffs at the time this alleged attack occurred. So it's kind of crazy because, you know, this case occurred 7 years ago. This attack occurred in 2013, September of 2013. We're before the court in a time in America where this police misconduct and excessive force is an issue. And here, my client brings the complaint to the city of Clarksburg, and they refuse to investigate who attacked this woman. And that is really the elephant in the room today that they want to ignore, is that my client is a victim of an attack by an officer in handcuffs, while she was in handcuffs. That's what the jury determined. The jury found that it was a city of Clarksburg police officer who attacked my client. We can't name him because they all testified inconsistent at trial. They testified inconsistent in their pretrial investigation. Judge Matish specifically cites that all the officers who testified at trial testified inconsistently with one another. So under Jutrowski was a different case than this case, because under Jutrowski there was an admission that excessive force had occurred. And under Jutrowski they admitted excessive force had occurred, and they remanded it back under a conspiracy theory, which is different in this case. They did not dismiss the plaintiff in Jutrowski. They remanded it back on conspiracy because the officers all denied involvement, but the evidence that the attack occurred was unequivocal, and the defendants in that case in Jutrowski admitted this attack did occur. But naming what we call in the law a shotgun approach, you name everybody that was there that night, isn't fair to every individual officer who was there that night. The city produced logs of every taser weapon that was carried by the officers that night. No taser weapon had been fired.
Counsel, isn't the whole idea of the John Doe designation in a complaint to allow the person to ensure, first of all, that they don't miss the statute of limitations because they don't know the person to identify? So they identify someone with the understanding that throughout the discovery process they're going to be able to basically fill in the blank, so to speak, and identify the specific person here. And that's really the purpose of a John Doe designation. If you allow that to go through the entire trial, are you not really opening up an entirely new approach of trying to hold people responsible when you've never identified and never specifically identified who that person is? And that's the concern I have in this case, is that we understand that your position is that you did the discovery that was necessary but your client was unable to determine that person. But if we allow that to continue completely through trial and then there's no ever a determination of who that is, aren't we really opening up an entirely new approach in terms of holding people responsible when you've never really identified who it is?
In this case, Your Honor, you're correct. John Doe was filed to save the statute of limitations. Here we are 5 years later, and they still say the attack never occurred and John Doe doesn't exist. And the fact of the matter is John Doe does exist. He is a real human being. He was a Clarksburg City police officer. So their argument before the court today is we were supposed to name somebody that they still say today does not exist. And what you have before you in this courtroom is you have an imbalance of power. They are very powerful. They control the investigation. They control whether you call in the West Virginia State Police. We're powerless. And our only avenue of recourse to hold a government entity responsible for gross misconduct is what this is. Let's just call this obstruction of justice. Let's call this that a jury spoke in Harrison County Circuit Court and named and said a Clarksburg police officer attacked a 47-year-old woman in handcuffs. Since that verdict was rendered in June of 2017, they refused to open an investigation. They are essentially creating John Doe. They've weaponized John Doe. John Doe is now a weapon to be used in this court, and they're asking you to render a judgment that essentially takes the power. We will have no recourse. We will have no recourse against public misconduct. We'll have no recourse against what in the case law, if you read the case law, they call the thin blue line. It's hard to get police officers to tell on each other. It's a fact. And I'll tell you another thing about this case that's very difficult. It's hard to get a jury to convict a police officer. You have to be very delicate in your approach when you go into a case like this.
Let me ask, again, it's my understanding that again, as petitioner referenced, in the deposition, your client, respondent, actually did identify the officer that had tased her. And even after that deposition and the identification, no amended filing was made. Was there ever a deposition taken of that officer that she identified in the deposition, or any of the other officers that were identified as having been present at the time of the alleged attack?
No, we had the benefit of an internal investigation where every officer was questioned by the Clarksburg Police Department, and all those audio statements of every officer was turned over to us. So when we took the deposition of the arresting officer, and then when they testified at trial, they all testified consistently with their investigation testimony, which was 2014.
But your point is, again, the desire to get to the heart of this, that an attack occurred, and to identify the individual. You had the internal investigations, but you were in those internal investigation tapes, apparently nobody fessed up and said they did it. You had your client identify an officer in deposition. Again, I'm just troubled by why, after you had the tapes, you had her admission or statement, why you still didn't investigate and depose to try to identify this. I'm concerned about the suggestion of a thin blue line and how difficult it is, and how you're basically throwing up the white flag and saying, I'm not going to ask because I probably won't get to the heart of it. But that doesn't relieve you of the obligation to try to get to the heart of it, to identify who conducted the act that she alleges occurred.
Well, in her deposition, Your Honor, respectfully, she said she didn't know. She never saw the weapon. She never could put a weapon in someone's hand.
But didn't she identify the officer? That's the officer that did it?
She thinks it was Lance or Harris. That was what she consistently was, which is a tall, thin, Caucasian male. But with her level of intoxication at .349, 2.5 hours after the attack, and we all know that you could back up her BAC. So, at trial, they would have bludgeoned us for naming someone who we couldn't prove that Jim Smith did this. And here we are 7 years after the attack and had a full jury trial. We still don't know, and counsel for the petitioner is still asserting that John Doe doesn't exist. So do you see where that leaves us as a dilemma? Is we would never be able to name an individual officer because they admit in their brief that there's not enough evidence to say it was Jim Smith. It was, a certain individual. So they're maintaining in their brief that John Doe is appropriate because there are no individuals after 7 years of litigation, 6 years after the investigation, there are no individuals that anybody will agree to the evidence shows that it was this guy.
Can you address, obviously we've talked about, and you've stated a position relating to whether or not under federal case law an individual needs to be identified in 1983. Would you mind addressing this issue of respondent superior and the attorney fees, and to what extent the insurance carrier of the city of Clarksburg is on the hook, as your suggestion? What is the federal case law on those issues, or West Virginia relating to 1983 claims?
Your Honor, the issue before the court at that time was the court had asserted that the petitioners in this matter, the defendants in that matter, had played a shell game. And that's exactly what the circuit court called it. He said, you're playing a shell game. One second you're saying that nobody did this to this woman. The next second you're saying, you have to name her the attacker. It's different in the other case law that you're citing, that they cited. The attacker was someone who could have been named. And in Jutrowski, the court remanded it back on the conspiracy theory because all 4 officers denied that they did it, but the defendants in that case acknowledged that it had occurred. In this case, they're not acknowledging that it occurred. They never brought an expert to trial. We had an expert at trial. And 7 years after the attack, we're no closer to naming the person than we were then. So what Judge Matish was narrowing in on is, you can't have it both ways. You can't play a shell game and say you have to name an attacker, but the attacker doesn't exist. That there's no evidence to show that Jim Smith did anything, but you need to name Jim Smith. So we were left in a dilemma before the circuit court. He was concerned that they had played a shell game. That's exactly how he termed it to him. You're playing a shell game. And essentially what he asked him was, if I dismissed the city who was a party to this shell game, because like I'm arguing to the court, they're all powerful. Our only recourse is the court system to hold them accountable for government misconduct.
And what I'm trying to search for is, again, the authority, either state or federal authority relating to respondent superior responsibility that obviously a petitioner has suggested does not exist. Do you have authority you want to present to this court that the insurance carrier is on the hook effectively for a dismissed party, the Clarksburg?
Under the issue of the shell game that the judge alleged the city was playing, that they were involved in a shell game, under respondeat superior, I believe he could have held him accountable. But to nix that issue...
Upon what theory of, what is the legal precedent supporting the court's ability to so hold?
Under Monell, which is the central case that most people cite, they talk about the criteria to be involved, and one of them is poor oversight by the governing institution, either lack of training, lack of oversight, and in this case, I believe the judge could have held the city in it had the petitioners not told the judge there will be insurance coverage even when you dismiss the city. I believe under Monell, in the facts of this case, Judge Matish could have said, you've played a shell game. You're ultimately responsible because you're contributing to what I term an obstruction of justice. Now, their own witnesses testified that the attack would have constituted an unlawful assault. If the attack, as we alleged, a person in handcuffs, a 120-pound woman, 47-year-old in handcuffs, if you did what you did to her as alleged, and as the jury found happened, and Judge Matish told him along the way, I think you're going to lose. He told him. He warned him. He even warned him along the way. He said, you need to be like good lawyers and good doctors, and you need to pay for your mistakes that you did. No acceptance of responsibility has ever occurred. So the city's before the court saying, please dismiss us under respondent superior, but we don't have clean hands. Our hands are unclean. And when the judge asked him, he said, and it's in the brief, he asked him, he said, don't you have a duty to investigate? Do you know what their response was? We're not going to prove his case for him. That's what they told the judge. It's in the brief, it's in the transcripts. We're not going to prove his case for him. So here we are, post-verdict. 2017, a jury says this did occur. Their own officers testified on the stand that if it occurred as we alleged, it constitutes a felony unlawful assault. There is no impetus on their part or no action on their part to find out who did this. They refused to investigate post-trial an attack on a woman in handcuffs. So here we are before the court in West Virginia when this excessive force stuff is all over the country. We all know it's happening. And here your ruling today, if you rule in their favor, is going to allow them to obstruct justice. There's going to be no duty upon them to look into who did this to this woman because they've taken the position it never occurred and we're not going to investigate it, regardless of what those 6 people in our community who sat...
Is it your position that the city had an obligation after being dismissed by the court, that they had an obligation to go back and try and investigate post-dismissal who, in fact, committed the assault that you allege?
No, post-verdict. So when the verdict came down and the jury said an attack did occur on this woman in the holding cell in the Clarksburg Police Department, okay? When the jury determined that, what does a good government institution do?
Well, they had been dismissed, and the officer that you had named was still in the case. And the jury made a finding, and had the jury made a finding that he was in fact the culprit, the coverage would have been there, but they said no, he didn't do it.
And we never alleged he did.
But you sued him.
Well, he was the arresting officer. That's the only way he stayed in the case.
You sued him. And
well, I mean, but in the allegation, there was no allegation that he did it. We had never made the allegation that he did it because we couldn't prove it.
Then how in the world did you get to where you are?
Because the evidence of the attack was apparent. So the court, the circuit court, when looking at the totality of the evidence, said, I believe an attack occurred. And he told them, you made mistakes. And he warned them. And he said, your argument is nothing more than a shell argument. Because
yeah, but legally, the judge said, there's nothing to hold the city in here. So he dismissed the city from the proceeding. A jury then steps up and says, it wasn't the officer. It was John Doe. So how in the world, and I get back to Justice Jenkins' question, what authority can you cite that says that the city is responsible for a John Doe who has never been identified?
Because during the argument under Respondent Superior, when the city was still a party to the case, the judge had made findings that they were playing a shell game.
Get past the shell game. Give me the authority under 1983 cases that allows a jury to make a finding against John Doe and have a respondeat superior argument stand up that the city is obligated to take care of John Doe.
If the criteria are met under Monell, which was up to the discretion of the circuit court judge, he's hearing the argument on whether they were responsible for poor training, poor supervision, poor oversight. We had a failure of an investigation. I mean, I can't attribute conspiracy to what looked like to be incompetence. But at the same time, they have continually argued before the court that, well, we're not responsible, the city's not responsible. So when that issue came before the court, the judge asked them, as the issue was pending before the court, he said, if I dismiss the city, which at that point, had he kept the city in it, we'd be here on another issue. We would be here under whether there was Respondent Superior liability.
You have not appealed the issue of whether or not the city was improvidently dismissed.
No, the judge offered them, and they said there will be insurance coverage, Your Honor, for the rest of the defendants and John Doe. And it's in his final order. He puts it verbatim on what they told him. So as a circuit court judge, when he's left with a decision, he felt in the best administration of justice. And that's where we're at here today, really. We're arguing what's in the best administration of justice when you have a government entity who's accused of a wrongdoing, who played a shell game throughout the trial, and then post-verdict is here before you under a John Doe defense when this attacker exists in our universe. There's no justice here.
Did you plead conspiracy?
No. At that point in time, we couldn't prove it. I mean, we just could not prove.
So you didn't plead conspiracy in the original complaint or the amended, and you've referenced conspiracy multiple times during your presentation. So your real theory is now, at this stage, post-verdict, where the jury deemed a John Doe responsible, your conspiracy theory only kicks in at that point, that you say, aha, the jury found an attack did occur, and we think that there is a conspiracy of secrecy, or and you want to run with that issue at this point.
I believe post-trial, this cover-up is troubling. It's very troubling that a jury spoke in Harrison County Circuit Court, found that an officer had attacked a woman in handcuffs, and here we are 3 years later, and I cannot compel them to do an investigation. So here I can't find out who did it to her, and under theory, my statute of limitations should still be alive, because I filed it ahead of the deadline, and here we are 7 years later, or 5 years after the complaint was filed. They're still saying that John Doe doesn't exist. They're still saying there's not enough evidence on the record to name a particular individual.
So you can go back under your theory and start from scratch on a conspiracy claim.
No. I wouldn't go. I can only go back on the excessive force claim as still told, because we filed it ahead of the deadline of the statute of limitations. 5 years later, they're still saying that the identity was never known, that they can't prove it. Their argument is, you can't prove who attacked her. I can't prove who John Doe is. You know, most of the 1983 case law involves where the attacker could be known, where the attacker could be determined, and you failed to name Jim Smith. You failed to name a certain individual. And I'll tell you another thing about this case that's crazy. Of the 3 officers who testified at trial that were principal potential targets, by the time we got to trial, one of them had lost his job for having sex with a girl he picked up on a 911 call. There's nothing we could do about it. Judge Matish said you cannot bring that up to the jury. You can't talk about him being fired for improper conduct.
Is that in the record?
Yes, it's in the record. And it was protective order that we could not discuss it during trial. We could, it was a motion to eliminate. Could not bring it up, okay? So that one officer, no good. His credibility, he was the named officer in the case. We couldn't trust him. The other officer who was involved had lost his job recently. The evidence that came through the newspaper was he got intoxicated on an opioid, checking a backpack of a vagrant person in Clarksburg. They found him under the influence of an opioid. He is no longer employed by the city of Clarksburg. The third potential officer who may have committed this act, which is a felony act, he's a sergeant now. So naming a conspiracy at this point was not possible. I mean, at this point, it appears to us, post-trial, their refusal to investigate, their refusal to want to find the truth. I mean, we're here for the search for truth.
So actually, I would disagree with you on one thing and ask this question. You elected to go to trial on in a 1983 case, and the city had already been dismissed, right?
No. The city got dismissed at trial when the jury was seated.
But you went forward and got a verdict, and so now, you chose to move forward with the claims that you had. How can you, and that's what we're looking at today, isn't it? We're not looking at what the city did post-verdict. We are examining here today on appeal whether or not the verdict was correct. And so while all of this discussion of post-verdict is very interesting, it's really irrelevant, isn't it, to our analysis here today?
No, because I assume you're here for justice. And I assume you're here for the fair administration of laws, which is the definition of justice in the Black's Law Dictionary. And here we have a known attacker by a jury verdict who attacked a woman in handcuffs, committed a felony, and is a police officer. And it would be, to me, your job as a court, because we have nobody outside of you. We can't go to the police and make them do something they won't do. Other than a federal prosecutor being involved, we have no recourse other than the court system. We played by the rules. We filed everything appropriately. Judge Matish said we did it correctly. He said it would have been improper to name all those officers when I can't prove he did this and he did that. But what I can prove is somebody attacked a woman in handcuffs who was in their care, custody, and control.
Then why didn't you appeal the dismissal of the city? Because ultimately, a 1983 claim could have been sustained under your theory against the city for failure to train, failure to have appropriate safeguards in place, whatever, that resulted in this woman's attack and resulted in the injury she incurred. The city is the ultimate. The city is the ultimate entity that could have, against whom a verdict could have been sustained. A verdict could have been found, John Doe did it, the officer did not, but the city is ultimately responsible for what happened had you kept the city in.
Because they warranted to the court that there would be insurance coverage once.
What does the warranty over coverage have to do with the obligation of the city to appropriately operate its police force?
Well, I don't think there'd be a difference if the city stayed in the judgment. They could still deny the investigation, which they have.
So what? You've got a verdict against the city.
I mean, every individual officer named would have had coverage. There's no dispute in that. Every individual named officer would have had coverage. That's not in dispute. Now, what they're saying is, since I can't name John Doe, there's no coverage for him specifically. That's their argument. Their argument is the individuals had coverage. So coverage on the individual level versus city level, I mean, this isn't trying to...
Thus, I get back to my point of, if the jury says John Doe did it, and had to have been a police officer of some kind, then the city is ultimately responsible. A verdict against the city would have been sustainable. A verdict against John Doe is not. You can't. You have not provided this court with any authority to say that we, under a 1983 action, can sustain a verdict that would the carrier or the city would be responsible for against the John Doe. You've not given us any authority.
Your Honor, what would be their word to a circuit court judge that there would be coverage if it's not enforceable? They induced the dismissal of the city. At that point,
you didn't appeal it.
I had no reason.
And that's the point that I'm trying to make here.
I mean, at this point,
that issue is not here on appeal.
I think maybe we're getting into there's a lot of areas that aren't before us, perhaps, that maybe we need to. I believe we understand your argument. Your time is pretty much expired, so unless there's any other specific questions.
I have no further specific questions.
Okay, thank you. Brief rebuttal.
Thank you. Don't feel like the Lone Ranger. You're not the first.
Just briefly to address a few of those points. First and foremost, coverage was never an issue, and we maintain that. It was never properly before the court the way it's supposed to be. Any decision that stemmed from a discussion about coverage, again, respectfully to the circuit court, it was an inappropriate inquiry at the time, and a dispositive ruling based on that shouldn't stem. I just wanted to address one particular issue. Well, I guess two. First, the implication that no investigation was done. An investigation pre-suit was done. That's how information was gained regarding these other officers, and he got those statements from other officers. It was unsubstantiated. Likewise, through the admissions here today, the respondent could not establish the personal involvement of any individual officer. And the answer to a question where the answer to when you don't have enough evidence to support a claim is not to rewrite the laws on statute of limitations on 1983. That's not how we do it. We dismiss that case. And that's what should have happened here, and it didn't. The city was properly dismissed. There was no inducement based on insurance for their dismissal. The respondent failed to establish that any policies, procedures, or customs were violated. And on the issue of conspiracy, that came up and tries to differentiate some of the Third Circuit's case law on that. I believe we supplemented the record. A second case was filed in this case by the respondent for conspiracy. Judge Keeley dismissed that properly months ago. But besides that, we would just reiterate our point that we ask this court to reverse the circuit court's decisions and hold that John Does are not an appropriate party for a 1983 action, and that the respondent has not prevailed in her claims. Barring any questions, I'll...
All right, thank you very much.
Thank you all.
This case will be submitted.
The next case for oral argument is also under Rule 20, State of West Virginia versus Stephen T. Walt, docket number 190447, an appeal from the Circuit Court of Preston County, West Virginia. And counsel, although Justice Workman is not here present in the courtroom, she is participating by viewing and listening to the webcast, and she will participate in the decision and opinion in this case. I'll remind you that each side has 20 minutes to present your oral argument, and we have added a clock right to the left of the podium so that you can monitor and keep track of your own time. With that, counsel for the petitioner may proceed.
May it please the court. My name is Jeremy Cooper. I'm here on behalf of the petitioner, Stephen T. Walt, who is appealing his conviction and sentence from the Circuit Court of Preston County. Mr. T. Walt was convicted of, following a jury trial, of one count of strangulation, which was the only count in the indictment, and he was sentenced to the statutory sentence of 1 to 5 years of incarceration with no alternative sentence. He was also sentenced to no contact with the victim in the case, with no limitation on the time of that restriction. And in fact, during the sentencing hearing, Judge Schaefer indicated that it would be a restriction for life, although those terms don't show up in the actual written order. I am going to start with that issue, which is the fifth assignment of error, because I believe it's the issue of first impression. As I identified it in my brief, I believe it's also an issue of first impression simply because it's so aberrant that no other circuit court has attempted to do that and had the issue looked at by this court. When the sentencing hearing took place and Judge Schaefer indicated that he was going to enter a lifetime no contact order, immediately to me did not pass the smell test, having been to many sentencing hearings involving domestic issues and never having had this particular remedy ordered by a court. I was not certain that it was something that was available for a court to remedy, and I asked Judge Schaefer to identify the basis for his authority to do that, and he could not identify it. I even called a number of prosecutors in other jurisdictions to find out if they were aware of that as a remedy and any authority of that nature, and none could. So, of course, I researched it myself. I've identified no case in which this court has upheld the ability of a circuit court to do that. I've identified no statutory law that would enable a circuit court to enter that type of sentencing provision.
Do family courts have the right under domestic violence to ultimately enter a no lifetime domestic violence order?
Yes, Your Honor, in the context of a second offense of a violation of an order.
Right. So in other words, they ultimately you can get, what is it, a 90-day, 120-day, or a 1 year, and then ultimately you can get a lifetime no contact in the domestic violence context.
Right. The length of the restriction after a second violation is not limited. It's in the discretion of the court. So in theory, it could be limitless. Which is, you know, closest approximation, however, this was not a domestic violence protective order proceeding. There was no allegation of the sufficient number of violations of an existing protective order. There was no notice of that nature. So I believe that it's not applicable to this situation.
And the court's order doesn't reference 4827-505, which is the authority for that extended domestic violence protective order, correct?
It does not reference that. Or
it doesn't reference any statute at all.
Correct, Your Honor. So, but in an abundance of caution, trying to find out if I was wrong, I tried to identify the different possible means that the judge could order this. The circuit judges, of course, have fairly broad discretion to enter injunctions and to control the conduct of parties pursuant to that authority. Of course, that's in a civil context. That's governed by the rules of civil procedure, and it's that power in the civil context originates in common law. But even there, the ability of a circuit court to enjoin an act as opposed to prohibiting somebody, well, to actually enjoin an act to prevent an activity by a person is limited to the universe of the county in which the judge presides. So the judge would not have the ability to enjoin conduct by the petitioner outside of Preston County. And at this point, well, I don't know for certain where Mr. Twalt is today. I know he's been paroled. But of course, the alleged victim in the matter is moved out of state, and I don't believe that there's any way that Judge Schaefer could lawfully restrict that conduct in that context, since it's not happening there. Not even withstanding the fact that it wasn't a civil action, it wasn't properly noticed for that remedy, and none of those preliminary provisions that would have to take place, the filing of a complaint and a motion for a injunction, none of that has actually been done in this case. But even if we just assumed that the court had basically a smorgasbord of remedies that it could order in any case, I don't think that it would apply here. What the court can do is enter a restriction as a term of probation, and enter a restriction on contact as a, well, it's really more up to the DOC, but as a term of parole also, and as a term of extended supervised release for sex offenses, which is not also applying in this case because there's no finding of sexual motivation, and of course it's not a, moreover, it's not a specified crime under that statute. So none of those areas in which the court does have that ability apply. Can also order no contact as a term and condition of bond, but of course we already have a final judgment in a criminal case, so there's no bond issue here. So I believe that there's simply no authority under which the court can do what it did. The respondent has not identified any source of authority for that, but has made a ripeness argument. And I don't believe that the ripeness argument is a proper method for this court to dispose of this question, because any sentencing provision that's outside of statutory authority can be dealt with on direct appeal. There's no case that's been identified or that I've ever seen in which this court has declined to consider a sentencing provision, even one that's not currently being enforced or not being used to the immediate detriment of the defendant. I know this isn't a Rule 35A motion, but the principle encapsulated there says that an illegal sentence can be challenged at any time. So I've identified a number of cases in which this court has considered the propriety of future restrictions, which all of which the court considered on the merits at the time that they were brought on direct appeal. I believe all the ripeness arguments that were cited by the, or ripeness cases that were cited by the respondent pertain to civil cases and not in the criminal context. And I simply believe that when you have an order naming a person and joining them, or preventing them from engaging in conduct under presumably the penalty of contempt, that is ripe. That is immediate case in controversy that is real. It's not an advisory opinion, and it's something that this court can and should consider in the context of direct appeal before any violation of the term has been alleged. The respondent also made a number of public policy arguments pertaining to the legislature's stated desire to, treat domestic violence with the seriousness that it deserves, as set forth in Chapter 48, Article 27. However, if the legislature deems this to be a desirable remedy, it could, of course, enact that and then give circuit courts the ability to impose such a restriction. It has not done so, and that's something that I don't believe that, in the absence of statutory authority, I think the court here has a responsibility to reverse that portion of the sentencing agreement rather than just permit something because it might be a good idea from a public policy perspective. That's generally not what the court does, and it's not the role that the court engages in. So I would ask that the court reverse that aspect of the sentencing order, at least to the extent that it doesn't grant relief on the other assignments of error and throw out the case entirely. I would move back then to the first assignment of error, and these next four go to the merits of the case, the actual conviction itself. The first assignment of error is a sufficiency of the evidence, and what petitioner argues here is that in order to prove the elements of the offense, the state has to show a causal connection between the restriction of airflow or blood by means of pressure to the neck and the resulting loss of consciousness or bodily injury as defined in the statute. And I believe that there's simply no medical evidence that establishes that there's a connection between that. The alleged victim claimed to have been unconscious at a certain point. She said she was not sure the means by which she became unconscious. There's separate evidence of a head injury, and it was the prosecution in the case, the state, which chooses what to indict. There were a number of different theories under which the state could have prosecuted this case, but it chose strangulation, which is a far more complicated count to prove than domestic battery, unlawful assault, or any other number of charges that it could have prosecuted. And in choosing to prosecute under this complicated multi-step strangulation statute, the state had the responsibility before obtaining the conviction of actually putting on evidence that there was a causal connection between the restriction of air or blood flow and these other consequences. And there were medical records that existed that were referred to in trial, but they were never admitted as part of the case, and moreover, as discussed in trial as part of the record, the alleged victim never sought any treatment for a neck injury to begin with, which is where the nexus with the strangulation case would be in the first place. So I simply think upon a review of the record, this court should find that there is not a sufficient evidence that there was a restriction of blood or airflow, or that if such restriction occurred, that it actually caused the loss of consciousness or bodily injury. That's the first assignment of error. The second assignment of error has to do with the court's handling of collateral acts evidence, which is the evidence of prior alleged incidents of strangulation by the petitioner against the alleged victim, as well as a police report that was created by the Sheriff's Department, I believe, whenever the alleged victim had gone to law enforcement prior to a previous alleged instance of strangulation. There are a number of different problems that I identified in the briefs for the way that this McGinnis evidence was dealt with. First, there was not a sufficient evidentiary hearing. If you look at the evidentiary hearing, which was held immediately before trial, the court was dealing with two issues. It was dealing with the recording that was taken by the alleged victim of the conversation she had with the petitioner, and it was also looking at the collateral acts evidence separately, I guess her testimony about previous incidents of strangulation and the police report. So there was examination of the alleged victim concerning the recording and the circumstances that the recording was taken in, who was listening to it in the household, and ultimately the court held that it was inadmissible because of the spousal communication privilege. However, the other issue that was dealt with during that same hearing, there wasn't any opportunity for the petitioner, for me, I suppose, to cross-examine the alleged victim on whether or not these collateral acts ever took place. The court essentially heard from the victim, did not give me any opportunity, as is reflected in the transcript, to discuss what had, to cross-examine her on any of her statements, to actually ask her about the other statements and have a record made on that that would be sufficient for the court to even find that the prior incidents took place. Without actually making a foundation and determining by a preponderance of the evidence for McGinnis that the collateral acts took place, it's improper to bring them in. Additionally, both under the Rule 403 and the relevance, it's the petitioner's argument that whether or not the petitioner had previously done these acts to the alleged victim was not relevant as to whether or not the state could prove the specific conduct that was alleged in the strangulation on the night of November 18th, which was the specific indicted event. Now, perhaps it would have been relevant in terms of a general domestic battery prosecution, but really although I will admit there was an element of credibility attack as part of the defense here, the primary defense had to do with showing that the specific elements weren't met, that the state hadn't met its burden with the specific charge that it had sought to prove. Also assign error to that under the balance between prejudice and probativeness and relevance under 401, 402, and 403. But perhaps more importantly and more blatantly in the record, the court ignored, despite specific objection, syllabus point 1 in McGinnis, which prevents the admission of collateral acts evidence based upon the litany of causes that are set forth under Rule 404B. So intent, motive, opportunity, absence of mistake, absence of accident. Instead of requiring the state to identify the specific purpose and instructing the jury concerning the specific purpose, the court went against the express language of the syllabus point 1 of McGinnis and gave that exact instruction, admitted the evidence under that exact set of justifications, which is not what this court has instructed circuit courts to do in trials when this type of evidence is being considered.
Has this court ever upheld a limiting instruction that used the litany that clearly McGinnis cautions against?
Certainly the respondent identified the Williams per curiam case, which I think was 23 years ago and has not been cited since.
That was my next question. Thank you.
The court did uphold